thank everybody for taking the time to meet with us today. I'm going to go ahead and see if I can share my screen so that you can all see some slides that we're going to share with you today. So I think that, can you all see the slides?
Yes, Jacob, you're good.
Perfect. So I think just a little bit of background. We're going to run through a little bit about the process that's happened to this point to get us where we are, and then provide a little bit of background about the statute and the changes that are proposed. We do want to make sure that we're addressing any questions that everyone has. So we're going to ask that people hold their questions until the end of the presentation. However, we're going to try to give as much time as possible for those questions because we want to make sure that we're addressing any concerns that you all might have about this bill and clarify any questions that you may have. So I'm going to go through some of the background and research a little bit quickly. So if there's any clarifying points about that, please let me know. I don't believe Lisa Beauregard is joining us on this call today, but we do have I haven't seen her on, she may or may not be, but we do have Karen Kringley from the courts as well, who will be joining me and helping to walk through the changes that are proposed to the statute. So to give a little bit of background about why this process is occurring, North Dakota has been engaging in juvenile justice reforms continuously for the past 2 decades. People have been doing a lot of great work. Individual parts of the system have been moving forward, but more formally in 2019, a Juvenile Justice Commission was established for 6 years to study and look at the juvenile justice system and ways in which the reforms that had been done to that point could be built upon, could be expanded to be more systematic, to be more cross-cutting, and to really identify where the juvenile justice system in North Dakota could be continued to improve and that outcomes could be improved. So that included a variety of different things, including a review of Chapter 2720, which is, I think, primarily what we'll be talking about today. So following the creation of the commission and the SAG put out an RFP for outside organizations to help with that assessment process. The Counsel State Government Justice Center, where I work, my colleague Josh Weber is on the line as well, submitted and were awarded that RFP to conduct that analysis. Just a very quick background, the Counsel State Government Justice Center, we're a national nonprofit, nonpartisan organization that works with all 3 branches of government across the country in all 50 states and local jurisdictions to improve outcomes for those who come into contact with the criminal and juvenile justice system. So we work across the country to really bring best practice and research and support jurisdictions in improving their systems. And so the process through which we worked with the Commission and SAG in North Dakota was to conduct analysis of areas of opportunity within North Dakota system. So that included an analysis of previous system improvement efforts, annual reports, available data, strategic plans. It also crucially involved an assessment of Chapter 2720 and all other relevant juvenile justice statute. We also wanted to make sure we were talking to people. So some of the people on this call today were part of focus groups that we have with law enforcement and sheriffs during the initial assessment findings. We also met with legislators, with judges, referees, public defenders, service providers, prosecutors, really child welfare, anyone who, or systems that work with the juvenile justice system to get a sense of how things were actually working on the ground, how that was disconnected from statute or connected to statute and policy, and also where people saw the greatest opportunities for continued improvement. And then we also looked at the data capacity of North Dakota. So we didn't have time during this initial assessment to do a deep level data analysis, a case level data analysis, but we were able to identify what sort of answers North Dakota could answer with its own data, how that data was being utilized, and where there might be opportunities to strengthen the use of data. The assessment process was structured around sort of 4 core principles. And these principles are derived from, we conducted a meta-analysis of all of the available research and best practices in juvenile justice And through all of that work and looking at what the research has shown to be effective, what jurisdictions implementing reforms have shown to be most effective in improving outcomes and protecting public safety, are 4 core principles of buckets of work. That first principle is the use of validated risk and needs principles. This is known as the risk needs responsivity model, but basically what the research has found is that even experienced individuals within the juvenile justice system struggle to predict reoffending rates or reoffending risk just on their own without the support of tools. For a variety of different reasons, it's extremely difficult. People are often colored by offense type, which is a poor predictor of risk level. There are other factors that go into that. But basically what the research has found is that even experienced professionals, it's usually a 50-50 shot at whether they could identify a use risk just on their own. So the use of validated risk tools to help guide decision-making really strengthens practice. It strengthens, making sure that the right youth are placed at the right level of service and receiving the right services. And so that's also connected to the needs portion of the model, where not only is it being identified the risk level and the correct placement for the youth, but also identifying what are the drivers of that criminogenic behavior where it exists. So recognizing that a youth may have a variety of needs, but there are specific needs that brought them into contact with the juvenile justice system specifically. And the juvenile justice system should be prioritizing working on those needs to get them then back out and maybe back to child welfare or to other service systems, but focusing on, what was driving the behavior that posed a risk to the community. And addressing that first and prioritizing that in treatment. The second principle is around ensuring that the programs that do exist are demonstrated to reduce recidivism and improve other youth outcomes and are being properly matched to those needs that have been identified. So really not just saying every youth gets aggression treatment or every youth must attend school or every youth has a curfew, but really tailoring the services and the supervision conditions to the specific needs of the youth and making sure that the services provided actually match those needs and can improve outcomes. So there's a lot of talk about evidence-based practices, and that can really seem like a buzzword. When we talk about evidence-based practices, what we really mean is that you are continuously looking at data to ensure that it's achieving the outcomes. So when you talk about program models, it's that there is a clear program model, a consistent program model, that it has a target population that is utilized consistently, and that the right youth are being matched to that. So it's less about making sure you have the alphabet soup of national organization and programs, so those are good, but it's making sure that what's working in North Dakota is being tracked and looked at. The third is to employ a coordinated approach across service systems, and that's something we're going to talk a little bit about later that we saw was a struggle for North Dakota. But oftentimes youth in the juvenile justice system are coming into contact with multiple systems, whether that's just the education system, whether it's also child welfare or behavioral health, but making sure that systems are working together to utilize resources effectively, to create shared case plans that don't place a burden on the youth and family by having 8 different case managers and 15 meetings in a week, and putting the onus on systems to work collaboratively together to promote positive youth development, rather than either having contradictory or difficult to understand concepts, but really working together. And then the fourth concept is around really making sure that what is provided meets the developmental needs of adolescents. So the research is really clear when it comes to cognitive brain development that youth are not just mini adults. It is not the same thing in terms of what you can provide, in terms of their relations to punishment. The adolescent brain is sort of hardwired to push limits. It's susceptible to peer influences. Youth and young adults are not really responsive to long-term consequences. But then also really on the treatment side, understanding the importance of positive peer influences, of engaging the family in any activities, and making sure that everything within the system is built around an understanding of the cognitive brain development of youth and adolescents, and not treating them as mini adults. So within these assessments, we found a number of key findings. And the first is that North Dakota lacked a statewide vision, purpose, and set of research-based principles to guide its juvenile justice system. And I want to say that that's not to say that there was not progress being made or reforms being conducted. There was pockets within the courts or within juvenile probation, within child welfare, within behavioral health, whether that was local communities or whether that was individual systems moving forward. But as an entire system, there was not one coordinated approach, one coordinated vision that was driving reforms forward in a coordinated way. And that was reflected in the statute, which links together deprived youth, unruly youth, and delinquent youth together, creates a muddled vision of what the role of the juvenile justice system is, what can be utilized, how services can be accessed, and made it difficult for systems to have a real shared vision of what the role of juvenile justice is and how it can be utilized to improve outcomes for the youth who do come into contact with it, and also to make sure that only the right youth are coming into contact with that system. We also found that North Dakota offered limited access to services without formal system involvement. So that was somewhat linked back to some of the confusion around, what is the role of the juvenile justice system, who should be referred there, how are services being utilized and prioritized within the system. And some of what we're going to talk about today is really making sure that statute matches what was happening on the ground anyways. So it won't always result in a large change in practice, and we'll talk about in terms of like school referrals for things such as truancy, that youth will have the same access to services, but they won't need that formal system involvement to get there. And that's really important to consider because of the impact that even an arrest and formal referral can have on a youth's outcomes. Even if that case is diverted, research has shown that just that arrest and formal entrance into the system can have negative consequences. We also found that North Dakota had limited capacity for evidence-based service delivery, quality assurance, and data-driven decisions. As mentioned before, this isn't just that, where resources allowed, there was the MST or the family functional therapy, but also there was a lack of consistent quality assurance to make sure that the services that existed were really sticking to and meeting the needs of the population. And the fourth sort of major takeaway was that North Dakota's juvenile justice statute was overly general, vague, and largely bereft of research-based principles and practices. And this is just a function of the fact that it hasn't been updated in something like 30 or 40 years. So the statute itself was just out of line with the best research into adolescent brain development, using the right terms, setting the right conditions, things of that nature that maybe were already happening in practice, but want to catch statute up to make sure that it's supportive and helping systems in juvenile justice reform efforts rather than maybe being a hindrance or creating more confusion when those reforms move forward. So based upon those findings, we in partner with the commission and the STAG, came forward with a series of recommendations to better align North Dakota juvenile justice policy practice and funding with research and state best practices. Those recommendations including decriminalizing unruly behaviors and developing pathways to services for those youth outside of the justice system. The second is establish more stringent criteria and research-based processes for system decisions, particularly detention and out-of-home placement. And we know there is a detention placement tool, that there is some more validated tools around out-of-home placement, but continuing to strengthen those and more formalize them and really spread that use across the system more generally. A third is to build a more robust continuum of community-based services statewide, and that's specifically for specific populations and communities that maybe don't have access to those resources, and putting a real focus on making sure that there's access to services in a way that does not require juvenile justice involvement just to gain access to those services, but actually reserves juvenile justice involvement for those youth who pose a public safety threat. The fourth is to strengthen statewide commitment to and capacity for evidence-based services. So once again, that's talking about making sure the capacity is there to follow through and use data to guide decision-making about what services to provide, and to follow through that those services are being provided in an effective way. And then to align state statute with system improvement recommendations and more generally research and best practice to support matching the right youth with the right level of service the right placement and the right quality of supervision and services. So to talk a little bit more about some of the statute reforms that are to support these recommendations, I'll turn it over to Karen. And I'll address, move the slide forward for you.
Okay. Good morning. Thank you for having us. This next slide just kind of shows a picture of the timeline. I don't know, Lisa Biergard, did you want to talk about this? Or I think Jacob addressed some of it, but it just kind of shows the points in time in the last 5 years as the state started to investigate better ways of doing juvenile justice practice.
Yeah, I don't know if we need to spend a lot of time on it, Karen, but the primary purpose of putting the timeline together was sort of to demonstrate for folks that that the Council of State Governments has really been working with us since late in 2015, after the 50-state forum in which the Council invited teams of people from the courts to attend a large meeting where they really began to unveil some of the best practice research that they had recently completed. And so North Dakota began to engage with the Council of State Governments at that point. And then we just kind of marched through over the course of this timeline what brought us to this point, and want to end that by saying that we're so pleased that we'll have the Council of State Governments with us for the next couple of years to continue to help us as we navigate our way through all of this system change.
Yeah, maybe even a good point there too is that probably 3 years ago, the Council of State Governments recommended that we move our YAZI risk assessment to an earlier stage. And so I think it was approximately in 2017 or 2018 that we began doing pre-screen assessments at the informal adjustment conference level. And we found that to be really helpful in determining which kids needed more intense services and which kids really could do well on their own. So all along, we've been making some systems improvements to our policies and practice manuals and the way we practice community probation, for example. But we have yet to do the big lift, which is to update our Chapter 2720, and that's really what we're here to talk about today. So the bill draft process really was an intensive one this summer. The Commission of Juvenile Justice formed a smaller work group to start working on the draft, and we began in June. You can see there the work group consisted of Representative Klamine, Representative Kim Koppelman, Senators Diane Larson and Jonelle Bakke, Lisa Biergard from the Division of Juvenile Services, Lisa Johnner, Corey Peterson from the Zones, myself from Juvenile Court, Travis Fink from Indigent Defense, and Tessa Vaughan from Burleigh County State's Attorney's Office. We spent hours pulling apart Chapter 2720 and really trying to insert a lot of more of our updated practice and procedure. And the first draft was introduced at the Interim Judiciary Committee on July 22nd. There was a comment period where we received, I think it was 4 or 5 pages, single-spaced of comments back from various groups. And we met in a series of meetings to address those comments and make revisions to the bill. The revised bill was introduced on September 24th. And since then, we have been meeting with various stakeholder groups, and we'll spend a lot of time actually this week meeting with various groups to talk about the bill draft. So maybe next slide, Jacob. So one of the most noticeable things for your everyday practitioner is that our current chapter contains everything having to do with all of our case types, delinquent, unruly, and deprived, all kind of mixed into one. And it's based off of a lot of 1960s language, despite many of the reforms and changes in procedure that we all have. So for a brand new practitioner, whether that's a new law enforcement officer, a new state's attorney, new defense attorney, or judge, reading Chapter 2720 can be difficult because woven amongst all of the sentences are ones that pertain strictly to deprived kids, and then a couple paragraphs on, it'll be talking about delinquent youth and what happens with them in detention. It's actually a difficult read and a difficult process. You really have to be a practitioner for many years to understand what's going on. Last legislative session, guardianship of a child was put at the back end, 2720.1, and that was an update to the probate code that it used to all fall under probate, and now most of the guardianships are happening in juvenile court. And then we've always had our, or at least since the 80s, Chapter 2721, which is about the Division of Juvenile Services. So the bill draft proposes that we break apart the chapter into case categories. We would leave guardianship of a child at the head, so 2720.1. We would then have a general section, the Juvenile Court Act, which contains lots of statutes that would pertain to all case types. Then chapter 20 or section 2720.3 will be the new unruly category, which will now, under the proposed bill draft, be called child in need of services instead of unruly, or kind of that old incorrigible, ungovernable language that we've used for many, many years. And then for deprived children, children whose parents have abused or neglected them, the bill draft proposes using the category of child in need of protection, or CHIPS. And so these acronyms are used in other states, and I think bring a better focus around what we need to do with those categories of kids. Delinquency, which are the kids who commit offenses that would also apply to adults, will be contained in its own separate section, juvenile delinquency. And then at the tail end would be the Division of Juvenile Services, the Department of Corrections section, which is proposed to be 2720.5. One of the most important things I think we're doing is updating our definitions using modern language. We've inserted things like graduated sanctions, which are things that we use in probation as we address probation violations. We've added a definition for restorative justice. We've added a definition for referral. We've added a definition for attendant care. So those are many things that as a practitioner we talk about in the practice of juvenile justice, but haven't really been contained in the code itself. And we've also, where the code has been silent as to roles and responsibilities, tried to more clearly identify who's responsible for what. So when the language is silent, what you see across the state is kind of a variety of practice. Like in some areas, the state's attorneys do this, and in other areas, the juvenile court office does that. And in this area, the probation officer is responsible for this. So just trying to clarify those roles and bring a more statewide uniform pattern to the way we practice. So just talking as, just follow up to what Jacob talked about with low risk kids. We all know that most of our kids, my own included, it's pretty normal for them to test the rules. And so we want to really be clear that we don't want to bring those unruly youth, those low risk, but sometimes high need kids into our same groups with our delinquent or criminal, high risk criminal kids. And so all of you have practiced probably for a long time, so you're aware that the unruly categories include ungovernable behavior or running away, truancy, the use of tobacco under the age of 14, and minor in consumption and minor in possession. Those have always been our unruly categories, those categories that apply only to kids because of their status, because of their age. In the bill draft, the way it's set up is that those unruly kids, children in need of services, all of those referrals except for minor in consumption and minor in possession would be referred instead of juvenile court to the zones for services. And that allows parents and families to access services without needing to have an arrest or a citation or a referral. The statute itself is very clear. In fact, on page 64, that a referral for a child in need of services may be made by a parent. And so I'm sure many of you, I know in my 25 years, there have been times where parents have tried to seek out the services that the juvenile court offers, and they've been told to actually refer their child for taking off at night, talking back, not doing their homework, that type of thing, and needing actually either some sort of a citation or referral by law enforcement. So this bill takes away and allows parents to access help without creating some sort of deeper end process for their child. It also requires more specifically for schools prior to making a truancy referral or any referral that they would give more information, such as whether the child is subject to any special education, individual education plans, and what efforts have been taken by the school to address any school behaviors. There is a sunrise clause that would limit schools from referring youth to juvenile court for minor offenses. The proposed bill says that would not take place until August of 2023 and would give us time to build in a process and a procedure for doing that. And it would only pertain to infractions and misdemeanors, with some exceptions such as against person domestic violence and drug possession and use on school grounds. The bill also requires the use of risk and needs screening tools such as mental health screening, trauma screening, in order to guide the decisions that we make. So no longer just relying on kind of the old juvenile supervisor gut instinct about what needs to happen, but really relying on assessed and validated screening tools. One of the things that I'm actually the most excited about is that we are broadening the bill draft, broadening the right to counsel for children in all case types, and specifically also for parents at the detention level. In a delinquency, all children would be presumed to have right to indigent defense counsel, regardless of the financial status of their parents. And this would take away a lot of the continuances you see where we have multiple appearances as kids either waive their right and then change their mind, or their parents just change their mind and we have to have forms filled out and other appearances. So I think having attorneys appointed right up front will be great both for prosecutors and for the defense attorneys, so they can start right at the beginning of the process. The statute itself also requires the use of a risk and need assessment. We have always used one, or since 2001, our state has used the YAZI to help guide dispositional decisions, but the bill draft actually has a specific statute similar to what you would see on the adult side with a pre-sentence investigation. We'd have a pre-disposition recommendation made by the juvenile court officers, which would use this validated risk and needs tool. It also really reduces probation extensions for very minor things like curfew violations. So trying to make sure that we don't keep kids in longer and longer and deep end them in the system. There's also a specific statute about the Indian Child Welfare Act, which is a federal law, but it brings that active efforts language right up front and center in our statute, which will be easier for brand new counsels and practitioners to see, and for the agency to see what's required of them when they work with Native American families. The bill draft also tries to limit the use of out-of-home placement and only use that costly resource for kids who really need it. We also, as we have in the last session with the required use of the detention screening tool, try to only use secure detention for kids who pose a serious public safety risk, and try to emphasize the use of keeping kids in the community or use of attendant care as more appropriate for kids where we need to locate a parent, for example. It also limits the use of just minor probation violations as a way to get kids in the custody of DJS, and requires that the probation staff use graduated sanctions as they address probation violations. And really, the goal is to use more evidence-based services and to create those. And so I think that'll be a continual work of the commission as we work for the next 5 years.
Thank you so much for that overview, Karen. Really appreciate it. I know we want to make sure we're giving time for questions and responding to any thoughts that you all have. But before we turn that over, I know we're going to have George Vincent from the Fargo PD who is going to speak for. And so I don't know, George, if you're on.
Yeah, thank you for the opportunity. Hopefully everybody can hear me. Just for those that don't know me, my name is George Vincent. I'm a lieutenant with Fargo PD. I've been with Fargo PD for 17 years, and most of the time as a supervisor, I've been associated with our school resource officer program, whether it be as a beat sergeant, a sergeant dedicated to the group, as a district commander, or more recently in my current role as a community engagement lieutenant. I had the opportunity to attend the SRO supervisor class and understand and value that and how that plays into this proposed legislation. And so a couple of the comments I'd just like to make about it. First, I'm a member of the SAG, which is why I'm talking to you. You might think, what's he doing? So I'm the law enforcement rep on the State Advisory Group for Juvenile Justice. And so really, I think this this bill puts our SROs in a better position to avoid being used in situations where they, in my opinion, shouldn't be. Those administrative school violations, some of those unruly status offenses that Karen was talking about. And a good example of that, if you all recall the South Carolina incident where the young girl wouldn't put her cell phone away. And so the school got tired of it. They couldn't, they just kind of threw up their hands and said, well, let's just have the SRO deal with it. And we see that from time to time, unfortunately. And that escalated into, a physical altercation and a black eye for SROs around the country. And so I think utilizing this legislation will be helpful in not using our SROs as a heavy hand for administrative school violations. I think it also provides a better match for the juvenile and their families to whatever the root cause of their issue is. It frees up time for juvenile court. They can focus on more serious offenses and cases, and provides a better outcome, I think, for kids and their families. That root cause behavior that's identified either through this diversion programming often accounts for the manifestation of the behavior that's in school. And so if a kid is being unruly for a certain, they're running away because parenting is inadequate or they're drug users, they don't have a trusted adult. They get to school, if we're throwing SROs at them for those types of things without recognizing what the root cause is, we're taking away from that SRO's ability to be that mentor that we're trying to assert themselves as. So I think diverting to the appropriate programming to address the root cause of the behavior will be much more, it'll be better for not only SROs, but for everybody involved, including the kids. So that's all the comments I have. Thank you.
Great. Thank you very much, George. And I think it's important to highlight, as George mentioned, that the purpose of this is not to limit access to services. It's to provide the right avenue to services for youth and make sure that the resources as part of the juvenile justice system are utilized appropriately on public safety risks and make sure that the right youth are being matched to the services in the right possible way. Also, as Karen mentioned with the sunrise clause, it's also important to note that there is a deferred implementation date coming with a lot of this. We recognize this will be a change in practice and want to make sure that everyone involved understands what the new processes will be and that those new processes will be effective. So as part of that planning process, we'll be working with focus groups and with representatives from across systems to make sure that the worries that people have in terms of how this will work will be worked out before they actually start it. It's not just going to be bill passes, July 1, suddenly everything is different. There's going to be that opportunity to make sure that this is implemented in an effective way. I know it looks like we have something like 69 people on the call today. So I think we can try to see if people have questions, if they want to unmute and try. If that winds up being overwhelming, we can move to see if people can raise hands or type questions in the comment. But for now, if anyone has an immediate question or concern, either based off something that was presented today, or we know that there has been some information sort of circulating within the community about this bill that you would like clarified, would love to hear from you all and have a conversation.
Hey, this is Lieutenant Luke Gardner from Bismarck PD. I'm in the Juvenile Services Division. We have civilian staff that does diversion programs for juvenile court and then some diversion straight from school resource officers. My questions or concerns regarding the bill, and I've read a lot of it, basically circle around the fact that a child in need of services basically makes it non-criminal now, right? So who investigates a runaway child? Are cops still involved with that? Are we still going to be the ones investigating that? And then if we do find the child, it's not an arrest anymore. So do we have the same abilities that we had before based on the fact that a runaway juvenile was an actual criminal violation?
Mm-hmm.
And truancy was a criminal violation.
I'm willing to give it a shot, Jacob, unless you, here's my initial thought about how it would work is, I think especially like on missing children, there's still other sections of the code that apply to that. So like the missing child law, the duty to report is 140935. So parents will still have a responsibility to report that to law enforcement. And law enforcement, there's also lost, missing, or runaway children, which is 126025. And then missing child reports are all in chapter 1268. So there, you take that report and you do what you need to do to list them as a missing person, just as you would for a missing adult, I think, following that process. I'm not an expert, but also in the bill draft, we've kept many of the same language around taking a child into custody. So you can see in the chins and chips section that a child can still be taken into protective custody. So if you come across a runaway who's been missing and is on NCIC as a missing runaway child, you can still take that child into protective custody or release to a parent. That language is actually just the same as it is today in Chapter 2720. You can bring the child before the court, taking them into protective custody. You can release to a parent. It maintains in that section the ability of the juvenile director, like myself, to make a temporary order not to exceed 96 hours to take a child into custody. So I see that much of that process still happening the same way. When you encounter a runaway child, if they say that they're running away because their parents are abusing them, you would file a 960 like you do today, and the Department of Human Services and the child protective workers would take that report and investigate that. So I think, to me, much of that will happen still along the same lines, if that answers or assists you in that question.
Yeah, thank you.
Mm-hmm.
And I think that answer from Karen, she did a great job. I think it also highlights within, you mentioned truancy in your question, and also want to highlight, for example, youth who are referred for truancy, they're diverted right now. So even though they're making that referral to juvenile court, and Karen can give the exact statistics on it, but the vast majority are diverted, and so they will still have access to those services that they're being diverted to. It'll just be through a different process. And through a way that doesn't include that record. So you talk about whether it's a formal arrest or not. And right now, I can say the Counsel State Government Justice Center is working on a research report around the long-term impact of juvenile justice involvement on employment and educational outcomes. And one of the things that questions will be asked is, on an employment or an education application is, have you ever been arrested? So under the current, and there's questions about whether you have to report that, but people would say yes to that if they've been been arrested under it as a criminal behavior. But if you change it to this chins or this chip issue, then that answer is no longer yes, and it helps eliminate some of those collateral consequences. So it's thinking through how can we make sure that individuals are still getting the services they need, but without the potential negative consequences of juvenile justice involvement for youth who do not pose a public safety risk.
Mm-hmm. Just addressing kind of that truancy example, the vast majority, I would say, 100% of the truancy referrals are received by the juvenile court from school principals or school administrators, and usually in the form of a letter accompanied with an attendance record, sometimes some behavioral reports. And approximately about 80 to 85% of those are diverted to programs that we have in the community. Those programs will be continued to be used. The zones will be able to make those diversions, but they'll also be able to do a family assessment. For most of us who've worked with truants, we know that so many different things can drive truancy. It can be driven by depression, for example. It can be driven by family dysfunction, child abuse and neglect. There's lots of things that play into truancy. And the zones are skilled to make those family assessments and to basically triage those reports, just as our juvenile court officer 3s are doing right now. The small number of kids that are currently ending up on some level of probation are usually getting a non-reporting probation status, where they're basically told to attend school unless they have a medical excuse, and then just referral to services in the community. And that's something that the zones can provide. I think the zones, and I think Corey Peterson's on the line if he wants to speak up, but they've taken a hands-off approach on a lot of those truancy cases because they've seen that as in the statute requiring juvenile court to take action. But we hate to have those kids sitting in our lobbies with kids who are committing felonies and requiring high intensive supervision for public safety needs, and see these more as families that need that, what's driving the truancy to be examined. Now, are we going to have kids who are committing burglaries and being truant at the same time? Yes, we will. And juvenile court will continue to take those burglary referrals and work those cases where kids are exhibiting criminal risk. But the zones will step in and have to take more responsibility over kids who are unruly or truant. And I noticed in the meeting chat too, there was a comment about some specific examples of areas about school referrals. That is the section that would not go into play until 2023. So there'd be time for all of us to meet and talk about that. But the idea is that, you know, we do have many schools in North Dakota that currently have involvement with like PYB, with local area diversion programs, where kids who misbehave at school can receive some sorts of services or classes or groups without needing to come through the juvenile court doors. And so I think the plan would be to talk about that and try to enable that across the state. So it isn't just available in our urban pockets, but able to be delivered more statewide. But we would have time to talk about that. Obviously, felonies that are committed on school grounds in a school day would still be referred, could still be arrested, could be detained. All of that process that you're using today would continue to apply under the bill draft. So if that helps.
Okay, we have a question, a raised hand from the Grand Fork SROs, whoever's representing that group.
Yeah, I'll go ahead and represent it. My name is Jordan Dries. Can you hear me?
Yep, we can hear you.
My name is Jordan Dries. I'm one of the SROs in Grand Forks. I guess one of the concerns that we have is, I know it's different throughout the state and across the area, and she was just mentioning, you know, that services are going to be different everywhere and stuff. But is there any money being set aside to develop some of these more services for the inevitable increase in these referrals? Because, like, you know, some of our services here, even with just referrals coming from juvenile court, are already backed up for 4 to 6 months before the child gets services, and that's through the court.
Yeah, I mean, I guess that's surprising to me, but I believe that it's very uneven across the state as far as access to services. I mean, the one thing the pandemic has taught us is that we've been able to deliver a lot of things through Zoom or Teams, classes and groups and assessments and screens. But I think part of the work of the commission, which is ongoing and will continue for the next 5.5 years, wants to continue talking about how do we have evidence-based services that are available statewide. So you don't see geographic justice where kids in certain areas get the best evidence-based services and kids in rural communities don't. You know, I'm the juvenile director in Fargo, but I serve the whole Southeast region, and my kids go to school in Barnes County. So I know what it means. Like, you want to be able to have the same high quality services no matter where you live for your kids. And I think that is the goal of the commission, to continue talking about that. And it is the reason why we put that 2023 start date in the bill for the delinquencies on school grounds. We wanted to have continued discussion and hope to obtain some funding for those programs to be statewide.
Yeah. And actually, you know, in this current bill draft, there's not calls for additional funding, but going to, you know, earlier talking about the research and the importance of cross-systems collaboration. I know we have Corey Peterson on the call, but really making sure that there are those conversations about where those service gaps exist, and how to make sure through those human resource zones that there is the correct access to services, and the services that community needs are being met, and utilizing resources more efficiently and more effectively. And that's part of the implementation process, part of the, you know, cross-systems collaboration between child welfare and behavioral health and juvenile justice systems. But it's just important to note that the answer to that question is, how do we make sure those services are available and being linked to the right youth, not to then fall back on the juvenile justice system as the answer because they aren't there right now if they aren't, or they're not being utilized properly or matched to the right youth if they aren't right now. So it's making sure that systems are taking that onus to say, how are we making sure that that gap is being addressed if there is that gap, rather than putting youth into the juvenile justice system to try to see it as a workaround if that gap does exist. I see we also have a couple of questions, so I'm going to try to go in the order in which they popped up. So Jesse Johnner, I apologize if I pronounced your last name.
Sure. Good morning, and thanks, Karen and Jacob. I was just going to echo what Jordan said. I think these are really good ideas, and I think we really do need to make sure that there's enough funding to do it. We're having that issue right now at the adult level with all the diversion and community service programs that we have through our jail and stuff, is they're just not being funded appropriately. In fact, right now with mental health issues, which we're dealing with a lot of times when we're getting referrals to go to different services there, they're getting denied because of the funding. So that was one important thing I think that we need to make sure is definitely available if we go this route, is that these programs can be sustained. Otherwise, I think it will cause issues on the back end and all that good stuff. So that's all I was going to mention, and I'm sure there's a plan for that, but I just want to make sure that there was.
Mm-hmm. Yep, I agree.
Yeah, we definitely want to make sure it's done. And I guess I should re-highlight, as Karen mentioned and we talked about, since the vast majority of youth like for truancy referrals are being diverted right now, those are the same services that you're talking about. That's the same services that will be utilized. It's not that juvenile justice right now is providing truant youth with services that they would not have access to in this new process. So it's not putting additional burden, I should say, on those services. We want to make sure that those service gaps that you all are raising are being addressed, and that the right resources are being put in the right place to make sure that youth are receiving proper services. But it's not really changing practice in terms of access to those services through this bill. It's just changing the process through which those services are accessed. And so I do want to highlight that this isn't going to be a deficit bill in terms of reducing the services that these youth will have availability to. But we do also want to take everything that you're saying and continue to involve you all in this process to make sure that where those service gaps do exist, that's part of the conversation and can think through how to manage that. But this isn't creating a service deficit where it doesn't exist.
Yeah, I was wondering, do you think it's a good time for Corey to mention the Families First prevention dollars that'll be available? Maybe not everyone's aware of that.
Yeah, sure, Corey.
Sure. Good morning, everybody. Corey Peterson, I'm the Director of Children and Family Services. Appreciate Karen and Jacob taking the questions. So North Dakota's been approved by the federal government to use federal 4E funding, which is typically used just for foster care, to use it now for services in the community prior to kids being removed. And so we've had that plan approved by the feds, and we are working on those service deliveries. I think the biggest piece, and I think both law enforcement agencies, from Jesse to the Grand Forks folks, bring up good points, which are, is there going to be funding? And I think any support we can get through the legislative process to just remind people that we, need to keep services where they're at and increase them where we need them. I think the other thing we have to be cautious of is we're not stuck in a trap of everybody gets a service. Not every kid needs a service. A lot of kids will grow out of this behavior over time. I know I did. The reality is we got to connect the right service with the right kids. I think larger communities in our state do have a lot of services. Do they have all the services? No, they don't. I think in our smaller areas and some of our, I would say semi-rural, like the Jamestowns, the Valleys, the Devils Lakes, they are definitely service deprived in when you look at the numbers of cases that they receive. So I think it's in the works, but I do think and like that people are kind of talking the same thing. Like we have to make sure those resources are available for families if we're going to make this really work over time. So.
Thanks so much, Corey.
And schools can apply for those, right? I think that's one of the questions in the comment is that schools can tap into those dollars.
Yeah, so schools, I've worked with a few of the public schools around how they can tap into those resources. There are a number of resources that schools can deliver, obviously, but they could also refer families to without having to engage any government systems. So there's a process by which you can have a case plan for a child that's in your school or on probation or wherever that child is residing in the system or not in the system, and have a case plan around how they could receive services if it's delivered in their home as an early intervention, or if it's services you can refer them to an agency.
Thank you. I see we have a question from Luke McKay.
Yeah, thanks. So one of the things that our civilian staff does at the Youth Bureau here is we meet with families and kids on attendance issues at the school, right? So I don't have exact numbers for you, but I would say that over 50% of those families that are invited into the school to talk about how to change those behaviors with the attendance don't show up. And then let's just flash forward now to this kid is 16 and now there's a possibility that they are truant from school to where now they would receive a citation. Was there any discussion at all, or is there any comments that you could give me as far as how do you hold those parents accountable if they aren't willing to seek out the services?
I mean, I have what I think the answer is, and I mean, I think we could proceed on a CHIPS on a deprived process if parents are really non-compliant with what they need to do to have their kids comply with compulsory education. Or anything else. So if it crosses that line, I think then it would be in Corey's world with the department. Correct me if I'm wrong, Corey.
Yeah, I mean, I think, and Luke, you know this just as well as I do. I mean, over time, you know, how kids and families engage in the school system and in our government systems is all different. And so I think now is the time with Families First. We know the federal funding is available for communities. We have to tap into that, but we also have to just look at families differently. You know, I'll use your example here in Bismarck. You know, Bismarck Public Schools have a lot of licensed social workers sitting in their buildings, master's level. They can provide these resources right in their buildings or go to the homes and provide service if they so choose. It comes down to, you know, somewhat of priority spending, but I think the engagement of families is different. Sometimes it takes, you know, a social worker from the zone. Sometimes it's going to take the school. Sometimes it's going to take maybe someone from your staff, non-civilian law enforcement. But I think overall, I think how we engage and how we access services is going to look a lot different in the next 10 years.
I would just highlight just in terms of the research, in terms of what services are effective. Some of that is program models. Corey Peterson talked about it's making sure that family engagement and how that family outreach is happening is done effectively and consistently, and there's a plan for it. And that's not saying that that's not happening right now, but what does that outreach look like? How many attempts are being made to go to the homes of that family or to reach out to them prior to those referrals being made? When you talk about really like the highest risk level youth and the services there's a program in Massachusetts called ROCA, and they say it takes anywhere from 15 to 20 attempts of reaching out then they work with young adults, but reaching out to a young adult before they actually start consistently coming to programming. So how is that being built into the process? But then also just in terms of the impact of the engagement, the research shown, at least within juvenile court, within delinquency proceedings, that involvement with the family through courts actually doesn't have as good of outcomes as when you can get the youth and family to buy in and to agree with the treatment and say, get to that point where they have that buy-in and they're saying, we see this as helpful, and recognizing that's extremely difficult work, but that actually leads to significantly better outcomes over the long haul than that court involvement, mandated involvement. So making sure that those steps are being taken first is an important part, and part of talking about evidence-based practices and using data quality. So it's not to say that that isn't happening right now, especially within individual organizations or within individual services, but those are some of the conversations about to what extent is that happening consistently, and how can that be supported and improved upon and built upon as well as part of this process. So thank you for that question. It's something that we want to make sure we're talking about, that these services are effective. But I don't know if there's any other questions. I know Amy, you posted a question in the chat. I apologize. I was making sure I was looking at hands being raised. And so I don't know if you want to ask your question via talking, or we can just read it off the chat.
No, it's fine. I think you generally addressed it. I kind of asked, outside of truancy, what are some other examples? And then, we look at that sunrise as being 2023, and, what's the game plan to walk toward having the right services in all these communities, so it doesn't end up just being then a new expectation of services that are just supposed to be delivered by the school, and how do we go about fulfilling that? So, and Karen answered that, that you have a game plan of getting to the place where we have those services the kiddos need.
Yeah, it's my life's mission, so I'm not going to forget. Don't worry. I'm on it. But I think giving us those 2 years, we're going to continue to reach out to you and talk to you about the process. So I think by putting it in the bill, it shows that we have a goal to try to have some of those like minor school fights, some of those smaller things, taking an extra milk in the milk line. Some of those should not be referrals to juvenile court. So,
right. I would absolutely agree. And then thinking about and I know I'm getting ahead of myself, but we just have to think that way. The training component for our schools and how we think about that out is going to be really important. So everybody's on the same page.
Yeah, I couldn't agree more. You're right. I think we'll have to work our way through like scenarios. When you sit where I do and you read every school referral, you just see such a wide variety of, very small things from very big things. So I think we're going to need to talk our way through what's appropriate for juvenile court to be involved in and what could be handled on a lower level.
Right. And then maybe even on top of that, from your guys' perspective, when we say now, okay, this level is no longer appropriate, what are some appropriate strategies to mitigate that within the school system? Yeah,
exactly. Where to go.
Yep.
Exactly.
Yeah, and I think, I know we're almost out of time, so if there's any last questions, people, please raise your hand or cut in. But I do think, it's important to note this sort of two parts to this. The first is right now is this education process around the bill as it moves forward. And we know that there has been some things moving around in the community about this bill and what it says and what it means. So we really encourage you, if you ever have any questions about a bill provision or someone says, hey, I heard that this means this and that sounds wrong to you, or please reach out. Everyone available on this call, whether that's Karen, Lisa, Corey, myself, please reach out with questions. We're happy to work with you. We want to be partners. And make sure that there's an understanding about what this bill is doing, and that if there is concerns about what this bill is doing, that we're addressing those and making sure that either people are assuaged and better understand the why, or if there is a real concern raised as oh wow, there's a lot of work put into this and a lot of people who work through this bill draft that it may not be perfect, and if there was something that was missed, we want to have that brought to our attention. So if there are any questions, please reach out. But then also, hopefully once the bill is passed, then there will be that process of implementation and building structures, and really looking for you all to be partners in that, to make sure that these concerns that we're talking about today are being addressed and used as part of the implementation plan to make sure that what comes out of this bill is working better than what's happening right now. And so really looking to you all to be those partners. So really appreciate you taking the time today, the time over the next few months to reach out with any questions that you may have. Excuse me, as well as to be that continued partner with us. So I know we're at the top of the hour. I do want to check back in to see if anyone has any additional questions, but just wanted to say thank you again, everyone, for your time and your questions and your engagement in this process.
It's Lieutenant Gardner again for Bismarck PD. Just one quick question. Can you expand more on the more formalized screening tool? You mentioned it in the presentation about the formalization of the screening tool. Mm-hmm. Can we get more information on that and expand on that just a little bit?
Mm-hmm. North Dakota Juvenile Court uses the Youth Assessment Screening Instrument when we screen kids, and that's built for kids with a delinquent offense. It does not work well, is not validated for unruly youth, and I think that is something we need to work on, that Corey will need to do too, to have a triage screening tool for unruly youth. But we've used the YAZI for many years. We've had it validated by the University of North Dakota in the last couple of years. We'd be happy to share those results with you, but it is a predictive tool for North Dakota youth. Youth that score high are more likely to recidivate with further criminal offenses. And so that's how we use that tool every day to case plan, and also to monitor risk in the community and to show the level of supervision we need to provide around high-risk youth, and also tells us to back off the low-risk youth and connect them to services. So, but I'd be happy to share. It's from a company, Orbis, and many states do use the YAZI.
Thank you. So we're talking about more than just like the detention screening tool. We're talking about all other screening tools. Thank you.
Right. The YAZI itself is there's a pre-screen, and it's a 2 hours 2-hour structured interview. We also use the MAISY-2 for mental health screen, and we have a trauma screening assessment that we use. And we also use a trafficking assessment tool. So, I mean, there are many out there, and I'm sure that we'd be looking, I think we're interested in finding an unruly, a truancy unruly type tool that we could use that would help us know how to triage those kids better than the way we currently are.
Yeah, and just to the question, I would add that right now, statewide, we're not screening those. So to the point of having to build something would probably be wise. We just haven't been over time screening those kids for the unruly behavior. There isn't, I'm not aware of one. Maybe Josh and those guys are aware of one. We've asked, I know Karen's asked the folks that do their assessment and have their screening tool around that. And well, that's not what their tool is built for. It's around recidivism of criminal delinquent behavior. So, as we know, and I'm just going to say it again, I mean, most unruly kids, a lot of these are the same kids that the zones are working with now. They're not new to the zones. A lot of them come from difficult situations. So that's not a really, there won't be a lot of new kids in that group. But I think we all know too that those are the kids that can cross over to delinquency. So we want to make sure we're providing resources to the family as soon as possible.
Great. Well, thank you all again for the time. I know we're already over the hour that we had scheduled with you, so appreciate it again. As any of you didn't get a chance to ask a question today that you're hoping to ask, or if it just comes to you later, or you just hear something when talking about the bill, please feel free to reach out. We want to see this as an ongoing partnership. This is a really exciting time for North Dakota, but looking forward to continuing working with you all as we move this forward. Thank you, everyone. I don't know if Lisa, if you had any last remarks.
No, thanks, Jacob. This is Lisa Jenner. If anybody would like a copy of the PowerPoint presentation or the recording, I can certainly email those out, and I will just leave my contact information here in the chat box. Thank you.
Thank you, everyone.